Tutorial video on the eviction process, tenant defenses in court, presented by the District of Columbia Office of the Tenant Advocate. Disclaimer: the information provided in this tutorial video does not and is not intended to constitute legal advice. Instead, all information and content are for general informational purposes only. In the District of Columbia, a tenant may be evicted for one of 10 specific reasons. However, all landlords must go through the judicial process. A tenant who is being lawfully evicted in the District of Columbia has the right to 1. A written notice from the landlord describing the reason for eviction. 2. An opportunity to cure if a lease violation is the basis for the eviction. 3. An opportunity to challenge the landlord's claims in court. And 4. Prevent the eviction by paying the full amount of rent if the action is for non-payment of rent. Tenants may assert the following defenses: tenant technical defenses, tenant factual defenses, housing code violations, and retaliation. Examples of tenant technical defenses. Tenant technical defenses include, but are not limited to, the notice provided by the landlord was insufficient in content, timing, or service. The delinquent rent owed is less than $600. The landlord did not provide the tenant a notice of past due rent in both English and Spanish. The eviction case is not for one of the 10 statutory reasons provided for an eviction. The notice does not give the landlord's registration or exemption number as required by the rent administrator. The landlord filed the eviction suit before the notice of past due rent expired. The landlord did not provide the legally required amount of time to cure the lease violation, and the landlord does not have a basic business license. Examples of tenant factual defenses. Tenant factual defenses include, but are not limited to, the landlord and tenant dispute the rent amount owed. The landlord claims the tenant did something they in fact did not do. The landlord claims the tenant did something that in fact is not a violation of the lease. The landlord claims the tenant did something that the tenant stopped doing, corrected within the 30-day period. The landlord's claim is retaliatory in nature. Tenant defense, housing code violations. A tenant may assert a defense based on a housing provider's failure to maintain the premises in accordance with the District of Columbia housing regulations. The court will consider the amount and severity of the housing code violations to determine the value of the unit. Severity of the housing code violations. A tenant must prove the extent by which the value of the premises is or was reduced by the condition. To use this defense, a tenant must prove that 1. The condition existed either at the inception or after the inception of the tenancy. 2. The period of time the condition existed. 3. The condition constituted a violation of the housing code or property maintenance code. 4. The landlord knew or reasonably should have known about the condition. 5. The landlord failed to repair the violation within a reasonable time. And 6. The effect of the condition on the tenant's use and enjoyment of the premises. Tenant defense, retaliation. The tenant claims that the landlord is retaliating against them for asserting a legally protected right. For example, 1. You are being evicted just after you organized or joined a tenant association. 2. You are being evicted for reporting a housing code violation to the District of Columbia government. 3. You are being evicted because you requested your landlord make a repair. Things to remember when preparing for the initial hearing. 1. Courtroom decorum. Be respectful towards the judge, all court employees, and the landlord and/or the landlord's attorney. 2. Prepare your defense. You have a limited amount of time to present your case, so prepare a concise, direct, and informative defense. 3. Bring your evidence. 4. Stay calm and composed. 5. Review the initial hearing video on the District of Columbia Superior Court webpage. If you have questions or concerns regarding the eviction process, tenant defenses in court, contact the District of Columbia Office of the Tenant Advocate.